Hello. Hi, good morning, Joel.
Hi, morning.
Hello. Hi, good morning, ladies and gentlemen online. So Joel is at office in Cast International, where I just finished my yoga. So I just do a sound check. If everybody can see us, can hear us, can you type in the chat box where are you logging in from? Which location? Alicia, Hin Kui Feng, Agnes Tan, Yvonne, Ko Eng Suan, Wong, where are you logging in from? Hi, Janani Gopal, where are you logging in from? Which location? Jonathan, Ailing, Kah, Devi, Yen Kim, where are you logging in from? Oh, from KL, Tan Yen Ying. How about the rest? Ivy, we just do a sound check. Just training is assume the rest also all of you today sharing on patent or not to patent, right? Hey, hello, can you hear me? Can you hear me? Hi Joel, can you hear me?
Yeah, I can hear you.
Okay, sorry for the delay. And let me put this up. Okay, so all of you registered for this because of free patent or not to patent. So in this master class, Joel is the senior patent executive now, and you can learn from him whether to decide when you should seek a patent or when you should as a trade secret. Okay, so let's put our hands together and welcome Joe.
Hi, good
Yes.
morning, everyone, and thank you for participating in today's webinar. So today we'll be looking at the topic of whether you should or should not patent an invention. Now today we'll be looking at a few subtopics. Firstly, give you a brief introduction into this topic of whether you should or should not patent. And we do a brief primer on IPR, just so that everyone knows. If you're not familiar what IP rights are, this primer hopefully will be able to help you to understand what are the basic IP rights that people can enjoy. Next, we'll look at what are patents and also what are trade secrets. We'll be looking at the comparison between patents and trade secrets. And then also we'll address the issue of whether you should or should not patent that invention. And after this webinar, we will have a Q&A session where I will try to answer as many of your questions as possible. So to start off, to patent or not to patent is a question that most inventors would ask themselves at one point or another after they have invented something. So if you're not sure why this question is being asked, maybe you can give a little context. So say you may come across a problem or an issue, and you have a great idea or a concept to address that issue. So some of these great problems, some people may ask themselves, maybe, how does one tackle global warming? Or how does one become a billionaire before 30? Or someone may ask, how do I try to understand the heart of a person of an opposite gender? Of course, people with great ideas tend to have solutions to these great problems. So as to the problem of how do I tackle global warming, someone may say, well, to tackle global warming, we must reduce carbon emissions. Or how do I become a billionaire before 30? To become a billionaire before 30, one can join a multi-level marketing scheme or try to resell limited edition sneakers. Try to dabble in some real estate investment, and probably this is not recommended. Can try to channel some money from the sovereign state fund through some confusing trail of accounts, and hopefully nobody notices the trail. Whereas for trying to solve the problem of understanding the heart of someone of the opposite gender, well, I don't have the answer, so you tell me. But I think about these great solutions or great ideas is just that they are just conceptual or ideal solutions. But what if you can reduce that great idea or great concept into a practical solution, something that you can use, something that you can produce, or something you can apply in reality? If you can do that, then you have an invention. So, for example, maybe we can look at some of these problems and think of some practical solutions. The first problem, maybe you can say, oh, my coffee is too bitter. So what's the practical solution? I just add more sugar. Or I have a message that I need to send a friend, but I don't want people who intercept the message to find out what the message is. So the practical solution that you can take is, first, my friend and I have a set of codes. And when I want to send my message to my friend, what I do is I'll write my message in code. So when my friend receives the message, it has a code. He can read the set of codes that we share, and he can interpret and decode the message. A third problem would be, say, if I have to bring a chicken, a fox, and a dog across the river, but I can only bring one animal with me at a time, and I cannot leave the chicken with the fox, since the fox will try to chase the chicken. And I cannot leave the dog with the fox, since the dog will try to chase the fox. So what do I do? Well, I'm sure you know the answer to this quiz. So you see, ideas are good, but ideas that can be reduced to practice is better. And if you have a practical solution which has a great commercial value, now that's the time when you start to have the question of whether you should patent that solution or should keep that solution as a trade secret. So for example, we are going to look into some of these cases, and hopefully at the end of the webinar, you yourself will be able to look at this case and be able to make a proper determination on whether you should or should not go for patent or trade secret in these cases. So maybe you might want to just take a mental note and probably keep this in the back of your mind as we go through the webinar later. So the first case is you develop a mee goreng recipe by grinding together peanuts and dried squid and lightly toasting the mixture before adding that mixture to the mee goreng. So by doing so, you manage to create a wonderful mee goreng that everybody likes. So do you apply for a patent for that recipe, or do you keep that recipe as a trade secret? Second case. As an engineer who is also a millennial, you observe that your fellow millennials, they tend to wear noise-cancelling earphones, and then they like to look at their screens. So when they walk in public, they tend to walk into traffic, they walk into sewage drains, they walk into train tracks, because they are all very engrossed in whatever they are looking at the screen. So as an engineer, you decide, okay, maybe I should invent a new type of earbuds that have a warning system. So whenever they are about to go into somewhere dangerous, the earbuds will warn them that there's something dangerous. So do you patent those earbuds, or do you keep them as a trade secret? Case number 3. As a chemist who also likes to cook, you get tired of scrubbing old grease that won't come off the stovetop. So you decide that you want to invent a new cleaning agent. So what happened is you mix together normally immiscible chemicals X and Y in addition to other chemicals, so that the resulting cleaning agent is able to lift the toughest of stains, and yet is biodegradable, does not have any adverse environmental effect, and leaves your house smelling like Chanel No. 5. So, you file a patent application for your method of mixing these chemicals and also the composition of the cleaning agent, or do you keep it as a trade secret? So think about these cases, and hopefully by the end of this webinar, we hope that you'll be able to make the answer on your own on whether you should go for patent or go for trade secret. So to understand a bit about whether you should go for patent or trade secret, you should take a quick look on what IPR and where does patent and trade secrets fall in this realm of IPR. So first off, what is intellectual property? Intellectual property or IP can be called a creation of the mind. So simply, this creation of the mind can be anything that you created using the mind. It can be expressed in many ways, such as ideas, concepts, inventions, symbols, designs, artworks, music, and so on. Of course, certain types of IP also enjoy intellectual property right protection. So commonly recognized intellectual property rights are such as patents, trademarks, industrial designs, and copyright. Now, patents are usually given for inventions. So if you have invented something like this fidget spinner toy, you can apply for a patent for it. Or if you invent a useful solution to a problem, such as a process for making high-yield petrol, you can also try to patent that formulation. The next type of commonly recognized IPR is a trademark. So you can register a trademark. Say if you have a business, you want to register your logo or your company name or your tagline, you can register them. So some of these trademarks are very popular, like for example, the golden arches symbol is registered by McDonald's. The Google trademark, which now belongs to Alphabet Inc., which is previously known as Google, and the Just Do It tagline, which is registered by Nike. Another form of commonly recognized intellectual property right is industrial design. So industrial designs registration is for the outward appearance of a product. For example, if you have a uniquely shaped bottle like Coca-Cola, you can register that design. Another IPR which is commonly recognized is copyright. And copyrights are for artistic and literary works such as Mickey Mouse cartoon character, or if you are a band and you make music and you create an album with a lot of songs, you can register your album art, you can register the lyrics of your songs, and you can also register the artistic performance of these songs as a copyright. Now, of course, there are other types of IPR which I have not gone into, such as geographical indication of goods, layout of integrated circuits, plant variety protection, but today we will not be looking into those. So now, what about trade secrets? What category do trade secrets fall under? Now, trade secrets, they have their own category, and depending on this jurisdiction, on the type of the country or jurisdiction, they have different types of law to cover trade secrets. So some countries, they have laws that prevent unfair competition. And some countries, they have laws that penalize the breach of confidential information. So it's a bit difficult to explain which law covers which, because trade secrets is a bit kind of technical, where in the sense that in Malaysia, for example, trade secrets are recognized as confidential information. So if somebody unlawfully discloses confidential information, then the owner of that confidential information can take action. But in some other countries, they have a type of law or rule that prevents unfair competition. So if somebody else tries to leak trade secrets, then they'll be charged under that law. So for you to know whether you should go for a patent or trade secrets, we'll look into greater detail about what are patents and what are trade secrets. So what are patents? patents are exclusive rights they are granted for inventions. So they allow a patent owner to exclude others from producing or working their invention. And if you want to know what inventions are, well, basically inventions are anything that permits in practice a solution to a problem. So these inventions can be a product, process, system, a formulation, or a composition. So in exchange for you disclosing your invention to others and teaching them how to work it, you get to have a limited time where you get to exclude others from practicing your invention. So this type of compromise is intended to help the technology to progress, because when you disclose something to the public will benefit from it, and also to reward you, you get to get this limited time monopoly. So of course, you can't just say I want to get a patent and go register the patent and get the patent. You need to make sure that your invention meets the basic patentability requirements. So in order for an invention to be granted the patent, the invention, firstly, it must be new, meaning that it's not disclosed anywhere in the world. So it may be all right for you to tell your spouse that you've invented something, but if you were to hold a press conference and go and tell everyone about your amazing invention before you've applied for a patent, then that press conference would be regarded as a disclosure to the public, and your invention wouldn't be new. Next, your invention has to be inventive. So what it means that your invention, it should not be obvious to a person who is working in the same industry. It's very hard to say what is obvious and what's not obvious, because if you consider from a viewpoint of a genius, everything is obvious. So the genius may look at somebody who's less intellectually gifted and say, why can't you see that it's so obvious? But for a technician, some things may appear to be very complex and very difficult, but if something appears to be very obvious to the technician, then it can be said that the invention is obvious. Thirdly, an invention must be industrially applicable. So what it means is that the invention must be something that can be produced or used in reality. You can't be going around applying for patents for things that cannot work or cannot function in real life. So say, for example, if you want to apply for a patent for a perpetual motion machine, a time-stopping machine, or a machine that grows food out of nothing, quite likely you will face rejection on industrial applicability. So for the last case where the machine grows food out of nothing, actually now recently there's this research that has shown, or is that demonstration that has shown that people are able to grow meat from cells in the lab. So if you're going to go and apply for a patent for new science, you probably have to explain that science and prove that science works. Or you think that the patent may be granted for any type of invention imaginable. Actually, there are certain types of inventions that are excluded for patentability. So even if you do invent something, if it falls within this category, you will not be able to patent it. Firstly, you're not able to patent what is a scientific discovery, a scientific theory, or mathematical method. So say if you were to develop a mathematical algorithm that allows you to calculate with great accuracy the amount of time that it would take for sleep-deprived office worker to start reading the pantry for another cup of joe, well, you cannot patent that algorithm. But if you were to make a machine based on that algorithm, and the machine cleverly predicts when the office worker needs a new cup of coffee, and at the time when he wants to drink coffee, the machine automatically produces the coffee without being instructed to do so, then you can patent that machine. Next, you cannot patent a plant or animal variety or any essentially biological process for production of plants and animals. So say, for example, if you have a new Musang King variant, you cannot patent that Musang King plant, but you can register that plant under the plant variety protection, which is a new type of IPR. Also, if you work in microorganisms, actually you can patent those provided that those microorganisms do not occur naturally, but are something that are artificially created. Next, you cannot patent schemes, rules, or methods for doing business, performing purely mental acts, or playing games. So if, say, you were to invent a new game, maybe like a Monopoly board game, you can't really patent the board game. But say if you invent toys or things that can be used to play the game, say for example, you invent the dice roller to make sure that the dice, when it's rolled, is always a random number and it's always a fair roll. Or you play or you invent a playing piece that gets brighter every time you acquire a property, you can actually patent those, the dice roller or the playing piece. Another invention that you cannot patent is a method for treating human or animal body by surgery or therapy. So if you have a method for curing a common cold or a method for curing a fever, unfortunately you can't patent that, but you can actually patent medicines that are used to cure the common cold, or you can patent, for example, if you have a medical method for finding out whether a person has a type of disease, you can actually patent that so long as that method is not applied on the human body. So say if you've discovered a new way to perform acupuncture, unfortunately you cannot apply for patent for that. But if you have invented a special type of needle that can be used for acupuncture, then you can patent that needle instead. So now that you have a rough idea of what you can and cannot patent, how do you go about getting a patent? Firstly, in order to apply for a patent, you must go to the patent office and file a patent application. And it needs to be said that a patent application only covers the country where you filed that patent application. So say if you file a patent application in Malaysia, that application does not cover the countries of Singapore or Brunei or say anywhere else in the world. If you really want to get patents in those countries, you have to also file respective applications in those countries also. Next, when you apply for a patent, unfortunately, the application will not be granted automatically. So it's not really like registering for driver's license or registering your business or company name. You have to meet patentability requirements before the patent is awarded to you. So when you apply for a patent, basically it goes through an examination process. So firstly, the application will be examined to see whether you made the right payment and fill in the right forms and included the right documents. Then after that, the application will be examined whether it's new, it's inventive, and then it is industrially applicable. And once the patent office is satisfied that your application meets all those requirements, then you can be awarded a patent. Now, the duration of a patent is 20 years from the date you have applied for that patent. And unfortunately, when you have applied for that patent, you don't really get the patent rights until that patent is issued to you. So the process for getting a patent can take up to about 5 years or more, depending on the complexity of the case and depending on whether your invention meets the patentable requirements. So if your invention is a simple invention and it clearly meets all the patentability requirements, you most likely can get a patent really quickly. But if your invention is something that it's borderline, it's not certain whether it's inventive or not, or you have a lot of issues with the application, then the application can take a while before the patent is issued to you. Now here are some examples of some famous patents that you may have heard of, or you may know of the invention, but you may not be aware that these inventions were patented. First invention is the US patent number 223898. Now this patent was granted to Thomas Edison for the invention of light bulb. And you may have heard of the quote, "I have not failed, I have just found 10,000 ways that won't work." It's commonly attributed to Thomas Edison, but whether Thomas Edison did actually try 10,001 times to create a functioning light bulb, well, that's a big question mark. Another famous patent is US patent 174465, which is granted to Alexander Graham Bell for the invention of the telephone. Now, as the popular story goes, Alexander Graham Bell, when he invented the telephone, the other company that was supposed to buy his patent thought that it was a toy and decided, I don't want to buy that invention. So what happened was that Alexander Graham Bell, he set up his own telephone company, and now that company is a major telco company in the US called AT&T. Another famous patent is actually for an iconic pair of jeans. Now, US patent 139121 was issued to Jacob Davis and Levi Strauss for use of rivets to reinforce pockets. So every time when you wear a pair of jeans and you notice that there are rivets near the pockets, well, those rivets were used to reinforce the pockets so that they don't rip easily. And for that, they were granted this patent. So now that you know what patents are, let's look at what are trade secrets. So to help us understand what trade secrets are, let's consider this hypothetical scenario. Imagine that there are two rojak stalls which are side by side. Both of these stalls, they use fresh fruits, they use fresh vegetables, they use omega-3 enriched farm eggs, they use fritters that are crispy on the outside and soft in the inside. But one rojak stall sauce tastes much better than the other stalls. And because this rojak stall sauce tastes much better than the other stalls, the stall enjoys better business than the other stall. So you ask the owner of the stall who has better rojak sauce, how do you make such an amazing rojak sauce? So the owner will answer, oh, my sauce is made out of the best ingredients and is made with lots of love and care. But of course, you may not be satisfied with that answer. So you ask, oh, what are the ingredients that you use to make the sauce? And the owner will tell you, well, to make my sauce, you just add a little bit of this, add a little bit of that, mix it with some love, and think about the happy faces of your satisfied customers. And there you have it, the secret to making my rojak sauce. Now, of course, the owner won't be forthcoming with the recipe for making his rojak sauce, because that recipe is his trade secret. So basically, a trade secret is anything that can give you an edge over your competitor. And if you were to share your trade secret with somebody else, then that competitive edge is lost. So a trade secret can be anything, like for example, the recipe that I mentioned earlier, or it can be a method of producing something. It can be a software code. It can be a method of doing business. It can be a sales technique. And if you are a magician who likes to create illusions, your magic tricks can be a trade secret. So here are some famous trade secrets that you may have heard of. First famous trade secret is for the Coca-Cola recipe. As you may know, Coca-Cola's made our secret recipe where nobody knows what the recipe is. Some people say or claim that they have disclosed the recipe, but up to now, nobody else has managed to replicate the taste of Coca-Cola. Now, according to Coca-Cola, the trade secret is kept in the vault in Atlanta, and the secret is only known to 2 employees in the company. So these employees are not allowed to travel together. And in the event that one of the person holding the secret passes away, the other remaining person is supposed to appoint a new person to pass the trade secret to. Another famous trade secret is Colonel Sanders' 11 herbs and spices. Again, people may claim that they have found out or discovered what is Colonel Sanders' 11 herbs and spices. So some people may say pepper and salt, and I guess that would be true. But as to how do you fry the chicken and how do you make it taste like KFC's. Well, I think nobody has come close so far. Now, the recipe to KFC's fried chicken is kept inside a safe that is placed in Louisville, Kentucky. And inside the safe, or rather, the safe is actually inside a state-of-the-art vault, which is surrounded by motion detectors, cameras, and guards. So it's such an amazing recipe. You can see how people try to use many methods to protect them. Another famous trade secret is a Google search algorithm. So every time you go on the internet and you want to look for something, you naturally go to Google because Google is able to give you answers straight away and hit you with the relevant website. So the question is, how does it work? Well, Google has explained briefly some of the ways that they enable the relevant search results to be displayed on your page. But as to how this is enabled, well, that's actually a trade secret. So that question you may want to ask is, how do you get a trade secret? Actually, you don't get a trade secret unless you do something to find out about the trade secret. Generally, the trade secret is something that you would own already, and it's not something you can get unless you buy it from somebody or obtain it through other ways. And unlike patents, you don't have what you call a IP authority that allows you to register the trade secret and grant you protection for that trade secret. So if you want to protect your trade secret, you unfortunately have to depend on yourself to make sure that whatever that you want to keep as a secret is a secret. So your mind is probably your best weapon to maintain your trade secret. There's no well-defined SOP to tell you how do you keep a trade secret. So what you may want to do is to see how do all these great corporations keep their trade secret and maybe learn a trick or two from them. So some of the measures that you can try to take to keep your trade secret secret is to restrict access to your trade secret. So what you may want to do is if you have a trade secret, say for example a recipe, and you want to keep it a secret, probably the easiest thing is to just commit it to memory and don't let anybody find out about that secret. Of course, sometimes you probably have to keep that secret somewhere so that you can share with somebody else. So in that case, you may want to keep it in a secure bank safe, or you may want to keep it in a secret vault somewhere. You also won't want to let anybody else find out where you keep the secret, or let them catch you doing or performing the secret. So it's like if, say for example, you own an Asam Laksa stall and you have a special way of cooking Asam Laksa, obviously when you're cooking the Asam Laksa in your kitchen, you probably want to lock the kitchen and make sure nobody else can spy your kitchen while you're cooking the Asam Laksa. So of course, when your business increases, sometimes you may have to share that trade secret with your employees or people who work with you. In that kind of case, it's best that when you share that trade secret, you write it down in a piece of paper and mark that paper as trade secret or confidential. And also you make your people who you are disclosing the trade secret to sign a non-disclosure agreement. So if anything were to happen, if you find out that there's a breach, and you can actually track down and prove that you have passed this trade secret to these people, you can actually sue them in court for damages because they have leaked out your trade secrets. Of course, in times of business, after the employee has served his term or decides to retire from your company, or if your employee is a non-performing employee, sometimes you may have to terminate these employees, and you may have this worry that the ex-employee may take your secrets away from you. So this is where the non-disclosure agreement will help you to maintain the secrecy. Now, of course, if you really want to make things a secret, what you can probably do is to hire a hitman to terminate your ex-employees. Of course, that's a joke, and please don't do anything criminal to keep your trade secret. Now, if you have a trade secret and that secret concerns a recipe or a process, one way to keep that trade secret is to make sure that nobody knows the entire recipe. So as you may have known about the KFC trade secret, what happens is they don't create everything in one plant. What they do is they create parts of the recipe in certain locations, and then it will be sent to somewhere where they'll blend the powder together. And people who work in KFC, they also don't know what the recipe is. All they know is they have this special flour or special ingredient that they have to use to mix with the chicken, and they have to fry it in a special kind of way. So by keeping all these processes and all these parts separate, nobody has the whole secret. And in that sense, you can maintain the trade secret. And say, for example, if you are required by law to disclose certain types of ingredients that are used, well, you probably can do it without disclosing your trade secret. What you can do is you can disclose the ingredients, and then you can probably add a few more ingredients just so that people don't know that actually these extra ingredients are not really necessary or involved in making your product or making your dish. Of course, you also don't need to tell anyone about how you're supposed to mix or process the ingredients together. And of course, sometimes you may have to be in a business where you need to disclose certain types of trade secrets to somebody who's working with you. And you may not want to tell them the whole secret. So what you can do is you can add extra dummy steps or extra dummy ingredients so that they are not able to find out what's the actual process or actual ingredient. So now that we've explained what are patents and trade secrets, we will look at whether you should go for patents or trade secrets by comparing them, giving you the advantages and disadvantages of applying for patent versus advantages and disadvantages of keeping a trade secret. So first off, the pros of applying for a patent is that the patent right is a right that is recognized by the courts. So if you apply for a patent and you have a patent, and say if somebody else is infringing your patent, you can actually bring the person to court, and you can actually sue that person for damages. Whereas as for trade secrets, just say that somebody else is using a process that so happens to be similar to your trade secret. Unfortunately, you can't really go up to the person and tell them, hey, you should stop using that process because that process is trade secret. If you do that, then it's quite likely that the person will find out that that special process is actually your trade secret, and that person will be alerted to your trade secret. This leads me to the next point, where patents give you the right to exclude others. So I explained before, when you have a patent, you can actually inform people that you have a patent, and you can warn them not to use your process, otherwise you meet them in court. But as for trade secrets, you can't really tell people that, oh, you are using my process or you are using my special ingredient, and you cannot use that because they will know that that's your trade secret. Next, since patents are something that are visible, you can use them to boost your value easily. Since patents are like IP, and IP has value, in case you need to attract investors to invest in your company, you can actually list down your various IPs and inform them, and they will make a determination of your value and invest accordingly. Unfortunately, trade secrets are a bit harder to show because first of all, it's a trade secret, so you can't really show people your secret unless you want them to find out about your secret. And sometimes when you sell a product and you say made using a secret process or made using some secret ingredients, it sounds very gimmicky. It sounds as if it's a marketing tactic. But since the patents are visible, people who see your patents know that a patented product has something superior in terms of its technology or its process. Of course, with advantages come some disadvantages. Firstly, you must bear in mind that not everything is patentable. So say if you have an invention that falls in the realm of non-patentable invention, unfortunately you can't go and apply for a patent for that. Also, if your invention is something that does not meet the requirements of patentability, say it's not inventive, or say it's not new, maybe it's an improved process or improved product, you can't really patent that also. So in that sense, you may have to think about how are you going to keep that as a trade secret or use some other method to get IP protection. Also, if you want to apply for a patent, you are required to disclose your invention in sufficient detail so that somebody else who is in the same industry is able to reproduce your invention. So if you want to keep some details or some steps to yourself, unfortunately, you are not able to because you have to disclose that in the patent. And say if you apply for a patent, but you don't disclose enough steps to make the invention work, that patent can be invalidated on the grounds that it's not industrially applicable. So you have to consider when you go for a patent, whether it's worthwhile to go for a patent or keep it as a trade secret because of this disclosure. Thirdly, a patent has a limited period of protection. You can't really gain exclusive rights forever. These rights only last you for 20 years from the date of filing the application. Unlike trade secrets, when you keep them, if nobody discovers that secret, it can probably last a very long time or even indefinitely. Fourthly, patent applications and the maintenance of patents can be very costly. So if you were to apply for a patent, say in Malaysia or in anywhere else, you have to be ready to pay for fees of up to tens of thousands of ringgit. So this can be very costly for certain people, and because of this cost, some inventors may forego going for patent application. Next, we will look into advantages of maintaining your invention as a trade secret. Firstly, if you were to keep a trade secret and nobody else discovers that secret can be yours indefinitely, and you can probably keep that secret with you until your grave. Whereas if you compare with patents, as mentioned previously, if you were to apply for a patent, you have required by law to disclose your invention so that people will be able to work that invention. As for trade secrets, you don't really need to register anything, or you don't have to do any special steps to get it registered because of its nature. So when you go for patents, obviously you have to go and apply and wait for the patent office to do all the examination before you get a patent. But as for trade secret, once you have that trade secret, you just have to make sure you keep it a secret and nobody finds out about that secret. Thirdly, trade secret can be utilized immediately. Unlike patents, trade secrets are something that once you have it, and you don't have to wait for some special period or some special time to use it. But for patents, say if you want to apply for a patent for technology, you are required to keep that technology confidential and don't disclose it to the public until you have applied for that patent. So in the realms of business, sometimes the timing can be very crucial. So if you were to wait too long until your application is been filed or granted, you may lose that window of opportunity. Of course, trade secrets comes with its own disadvantages. Firstly, once a trade secret is disclosed or is out in the public, it cannot be reversed. So if somebody else steals that secret and publishes it, and if it hits the nail on the head, then fortunately that secret is out, and you can't take what is out and disclose and keep it a secret again. Next, if you want to keep the secret, it can be a very costly affair, especially if you're running a big business and you're required to share your secret with other people so that you can scale up your business. Now, of course, if you are just a one-man show, a person who's just running his own stall, you can very easily keep that secret. But if you are, for example, the owner of KFC and you need to share your KFC recipe with others, it becomes very, very tricky to make sure that all these secrets are kept. So as you may recall, these steps that are involved in making KFC, you got to make sure you have separate locations to create the recipe separately. You got to make sure that nobody knows the secret, and you got to make sure that nobody knows the entire process. So doing all these things can cost you a lot of money. And lastly, to keep a trade secret and enforce it is very difficult because sometimes you have nothing to enforce. You can't really stop a person from legitimately coming up with a process that happens to be the same as your trade secret. So say if the person happens to be a researcher and they done some research and they came up with a process that's the same as your trade secret, you can't tell the person that you have stolen my trade secret because they have actually did it independent research by themselves. Also, if in the event somebody steals your trade secret and uses it, you have to prove in court that the person has stolen your trade secret and that the person has used your trade secret and that you have suffered loss because that person has used that trade secret. So to enforce a trade secret can be very difficult, and sometimes you can't enforce it at all. So now that you know about patents and trade secrets, the next question is to ask yourself is whether you should or shouldn't go for patent, or whether you should go for a trade secret instead. So how do you decide whether you should go for patent or you should keep your IP as a trade secret? Now here are some points that you may want to consider whether you should go for patent or you should go for a trade secret. The first question you may want to consider is whether your IP is more valuable to you as a secret or as a patent. Now, if you have a recipe, you know that you cannot patent the recipe, so that recipe will be more valuable to you as a secret. But if you want to go for patent for a recipe, unfortunately, the recipe doesn't fall in the realm of patentable invention, so you can't really patent that. Sometimes you may have a process that you can patent, and you may foresee that people also like to use that process. So if you have a patent for that process, you can actually license out this patent to others and gain some licensing fees. So in that case, the patent will be more valuable for you. Next point that you may want to consider is whether your invention is easily reverse engineered. Now for apparatus like say vacuum cleaners or cars or even mobile phones, if you have special parts or if you have special parts or components, these components can be easily discovered if somebody were to dismantle the entire apparatus and look at each component individually. So in these cases, you may want to consider going for a patent because people can easily reverse engineer your invention and find out what is the key component. But if your IP relates to a recipe or a special process, it may be quite difficult to reverse engineer the dish or the chemical component and find out what was the agents used in making that recipe, or rather in making that product or chemical. Another consideration to ask another point that bears consideration is whether you can keep something a secret. Now, if you have a recipe and you know how to prepare the food in a place where nobody else can see, then it can be said that it's easily kept as a secret. But if, say, for example, you run a stall and then you cook the stall in full view of everyone else, then it's very hard to keep it as a secret. So in that kind of case, you may want to consider whether you should or shouldn't keep it as a trade secret, or you should find some other better ways to keep it as a secret. One more point to consider is whether something is patentable or not. So as we mentioned, some inventions are excluded from patentability, such as the method of treatment, business method, biological processes to create plants and animals. So in that kind of cases, if your invention falls in categories, you may want to consider whether you can keep it as a trade secret or find somewhere else, some other means to try and secure your IP. A fifth point that you may want to consider is whether somebody else will be able to arrive at the invention and try to patent it. So say if you are in an industry where you produce a certain product and you have a rival company that's also doing research in the same area. If you don't quickly patent your breakthrough, somebody else who is doing the similar research may discover that breakthrough and they may instead patent it. And in so doing, you'll be prevented from being able to apply for a patent. And worse, they may control that technology. So instead of you having exclusive rights to the invention, the other person who applied for a patent first would be able to get a patent for that technology. So going back to our initial cases, for the recipe for making mee goreng, should you patent or should you keep that recipe as a trade secret? Well, it's definitely better to keep the recipe as a trade secret because it's very hard for somebody to find out about the cooking process from the flavor of the food. Of course, you may have people who have sensitive taste buds and they may be able to detect the presence of an ingredient, but even that, they won't be able to know how much of that ingredient to include into the recipe, or they also don't know what's the step of including the ingredient in the recipe. Case number 2, if you have invented the special Bluetooth earbuds, it's better that you go for patent because it can be easily reverse engineered by somebody else. So if your competitor were to buy your earbuds and bring it back to their laboratory and reverse engineer it, then they'll find out what are the components that are used to create your special earbuds. So in this case, once you have a working prototype and you have sufficient information to go for a patent application, it would be best if you go to file an application to cover your Bluetooth earbuds. Case number 3, should you patent or keep it as a trade secret the process for mixing the normally immiscible chemicals and also the composition for making your cleaning agent? Well, actually, for case number 3, it depends because you may be able to keep the process as a trade secret at the moment, but if somebody else were to do some research and find out about it, they can then you cannot stop these people from using that process. And if they decide to file for a patent application, you can't stop them either. But if nobody else is able to come out or arrive at a process through independent research, then your secret is safe with you. So it may be better to keep it as a trade secret. So in conclusion, whether you should go for patents or trade secrets is something that is very subjective. Firstly, you must bear in mind that patents grant owner exclusive rights to invention, and you have these exclusive rights for a limited time only. And in order to get a patent, you need to disclose to others how do you produce or work the invention. As for trade secrets, trade secrets are anything that will give you a competitive edge over the competitor. The thing about trade secrets is that they are confidential. So if these secrets are out, then you would have lost those secrets and you have lost your competitive edge. So this question of whether one should pursue patent protection or should maintain the invention as a trade secret actually depends very much on the circumstances, and you can't really say or can't really put everything in one category or the other. So that concludes the presentation. Right now, I'll be answering any questions that have been asked. Thank you. All right, it appears that we have a question over here. So the question is on patent application. So patent application is published 18 months after filing. What is the purpose of the publication? Well, when you apply for a patent, that's correct. You will have 18 months after the application when the application is published. So the reason why it's published is so that the public is aware that there is a patent application. So if there's somebody who is going to be affected by that patent application, what they can do is they can, in some countries, they're allowed to oppose the application. And in Malaysia, however, if you are aware of a patent application and if you are aware that if that patent will be affecting you in your doing your business, you can actually go to the court and prove that that shouldn't be allowed as a patent.
Yeah. Okay. Hi, Joel.
Hi.
Yeah. Thanks, SP, for your question. So next, any more question? So I mentioned your name. If you don't have question, you type 0. If you have question, you type 1 and then you type your question, okay? Or SP, maybe you can let Joel answer your question. So now I will mention your name. If you don't have question, you type 0. If you have question, you type 1 and then we will wait for you and then you type your question in, okay? So Sue, any question? 1 or 0? Diana, SP, Zainizam, Alicia, Hin Kui Feng, Agnes Tan. Any question? 1 means got question, 0 means no question. Okay. Then Yvonne, Janani Gopal, John Tan, Kalin, Ivy, Glazer, Ian, Rachel Ng, Angel, Esther, Amanda, Hui Ying, Nur Zatil, Kahling, Minyi, any question? No question. Oh, so no question. Most of them no question. So Joel, yeah, I put here people doing yoga. Okay, so yeah, so no question. Oh, so no question.
Oh,
so
right.
Joel, never mind. You want to give?
Anyway, later on, if there's any questions, you can always email me. I think you've seen my email address. If not aware about, you can send in your inquiries at cas@cas.asia, or you can personally email me at joel@cas.asia.
Yeah, okay. So I think with that, then we can end the webinar. Or you have anything else to say, Joel? Or you can give them some question to
I'd
answer.
like to thank everyone for participating in the webinar. In case there's any inquiries or anything that's not clear, I'm always reachable through email.
Yeah. And Joel, this is your first webinar. How you feel?
Well, I just hope that my audience didn't get bored because it can be quite dry sometimes. So try to make some jokes, and sometimes the jokes may not be funny at all.
Okay. Never mind. We just do a survey one more time, okay? So are you all happy with Joel's presentation, or you all feel very bored? Okay, type bored if you feel bored, happy if you feel happy. Then we let Joel know. Honest feedback, Joel. So Sue, Diana, SP, Zain, Nizan, Alicia, Hin, Agnes, happy or bored? Okay. Yvonne, Janani, John, Ivy, Glazer, Ian, Rachel Ng. Are you happy with the presentation? Happy or bored? You're so boring. Gideon, you just enter, Gideon. Didn't see you just now. Amanda, Hui Ling, Nur Zatil, happy or bored? Okay, Kaling, Minyi. So Joel, you see? These are their feedback. Happy, interesting, thank you. Happy, informative, good, happy, thank you. Clear, informative, happy. LOLs. So okay lah. So everybody is happy. And then this webinar is actually a sponsored webinar. Means you attend Joel's webinar live lah. Some of you attend live, some of you halfway only attend, some of you log in, attend already, then the client or boss call you run away, attend to them, then after that come back and then you miss some parts. So not to worry, because this is a sponsored webinar. You get the replay, you get the webinar replay, you get to attend the webinar replay, and after that, upon completion, You also get a certificate of with the Pila all of you. Life will be great. Oh, Joel, this is Esther. Esther said, if you have a live example. Just now you give case study, right? Those are real life example, right?
Think about trade secrets, very hard to give example because you know a lot of secrets, so it's very hard to be able to share your secrets, right? But thank you for your comment. In case I have to host another, I'll make sure I add more live examples.
Okay. Thanks, Esther. Acceptable and have improvement. Okay, let us know whether what kind of improvement we need to have. Okay, so so we end this webinar since everybody is happy and I'm also happy and Joy also happy. So thank you very much.
Thank you.
Okay, bye. Bye. Happy.